This case has its genesis in the gubernatorial election of 2014. My client, Charlie Earl, was he sought to be the Libertarian Party of Ohio's gubernatorial candidate. The Libertarian Party of Ohio had been kicked off the ballot by the Ohio legislature, which passed a statute called SB 193. Mr. Earl and the Libertarian Party of Ohio challenged that statute in federal court. Filed the challenge in October 2013. And by January of 2014, Judge Watson, the United States District Court, had enjoined application of SB 193 to the 2014 election. Only the 2014 election. He found it was just passed too late in the day to satisfy the process, which meant that the Libertarian Party of Ohio was entitled to a primary. Mr. Earl was the sole candidate running in the primary. He collected enough signatures. He was certified by the Ohio Secretary of State, and he was ready to go. On February 21st, 2014, out of the blue, a protester came forward. His name was Gregory Felsosi, a member of the Libertarian Party of Ohio, and he protested Mr. Earl's petition. Mr. Felsosi argued that one of Mr. Earl's circulators, a gentleman by the name of Oscar Hatchett, had been paid by the Libertarian Party of Ohio, which the Libertarian Party of Ohio never denied, and in fact had filed proper forms. And therefore, he needed to disclose on his every part petition his employer. It's called the employer statement rule. And Mr. Hatchett did not.
I hate to run you too far ahead, but the bottom line here is whether the money that was spent to try and keep this person, to keep Earl off the ballot, should have been declared as an in-kind contribution by the Kasich campaign. And I mean, there's no political novices in the room. The fact that the Kasich campaign benefited from it doesn't automatically mean that they have to declare it, does it?
No, you're exactly right.
So why here should they have had to declare what the benefit that Terry Casey bestowed on them, especially if he didn't coordinate with the other folks?
He did coordinate, Your Honor, and that's why they have to declare it. Under Ohio's campaign finance law, if the Kasich campaign or its agents coordinated with Mr. Casey or consented to Mr. Casey's actions, either one, then it's an in-kind contribution. The Ohio Campaign Finance Handbook provides the classical illustration where a third party hires someone to help the campaign with the campaign's consent. The Campaign Finance Handbook says that's an in-kind contribution and it has to be reported. There's no doubt.
I'm sorry, I didn't catch you off.
No, please go ahead.
It seems like we have a statutory interpretation and or procedural issue. It's really at the heart of what we need to discuss. And just to sort of cut to the chase of my assessment of what the issue boils down to. First of all, if the commission had said we're dismissing this for probable cause, if they said that expressly, would you be here?
No.
Okay. Now they did dismiss it, correct? Now I read the Administrative Code provision 3517.111A2, and I think I forget what subsection it is. I didn't write that down, but it's the one that talks about can dismiss, and then it lists 3 reasons why you can dismiss: lack of jurisdiction, which nobody is contending is relevant here. Insufficiency of the complaint and lack of probable cause. Well, so it seems like they did dismiss. So there's one of 3 reasons why they dismissed.
No, Your Honor, that's not correct.
Well, why isn't that correct? Because that's the heart of my concern. I look at that. I know they dismissed. I forget whether you or your colleague pointed out that what the lawyer said to the commission, that it was all about probable cause. At least they quote testimony from the hearing to that effect.
I argued that, Your Honor, they did not.
Well, that's what I said. I couldn't remember who it was, but it sounds like you were contesting, you were saying that, hey, this is all about probable cause. They grant the motion to dismiss. Something will, and then the statute is clear, you can't appeal from that because nobody disputes this was a preliminary review process. I don't see what the problem is here.
Couple things, Your Honor. First off, they never argued a lack of probable cause. Every argument they made in their motion was either legal interpretation or an affirmative defense. So they never made the argument.
But is that just another way of saying sufficiency of the complaint?
I don't think so, Your Honor.
Well, why not?
Because
And what's the difference between sufficiency of the complaint and lack of probable cause? I'm not even sure I even need to know what that difference is, but either way, it's sort of like, well, you just haven't either presented enough evidence to show a violation, or you just haven't stated a claim. I mean,
just well, I'll come right back to what they argued, Your Honor.
but you see where I'm coming from.
I do, Your Honor.
Okay.
First, I want to talk about OEC 3517-1-11A, which I believe is what you cited.
Yes.
You are correct. It does say that the commission, at its preliminary review,
Right.
may dismiss for lack of probable cause or insufficiency or lack of jurisdiction. It goes on to say, in subsection E, it may also make a final disposition of the case and do one of the following.
Yeah, but it didn't do that. It dismissed.
It didn't clearly say that we are dismissing for lack of probable cause.
True, but there's only 3 reasons why it could. Lack of jurisdiction, which nobody is contending here, insufficiency of the complaint, or lack of probable cause. And so it's got to be one of the other 2 because they dismissed.
I disagree, Your Honor. They dismissed.
That's where I'm missing.
They dismissed for a number of reasons. It could have been for lack of probable cause. It could have been on the merits. It could have been for
Not
First
under the
Amendment.
statute. They couldn't dismiss under the statute or under the code provision. They can't dismiss. Dismiss is up above. They could rule on the merits, but you wouldn't dismiss. You would just rule on the merits.
If you're correct, Your Honor, that every time the full commission on preliminary review dismisses, that's the end of the case. And there could be no
Yeah,
appeal.
correct.
This court in Common Cause, Ohio, said rules should be construed and applied to effect due process and just results. To apply the rules in a manner allowing the commission to dismiss any action for any reason without its decision being subject to judicial review would clearly be an unjust result. This court in Common Cause said just because you dismiss it doesn't mean there's no judicial review. So your interpretation...
But common cause says if you dismiss for lack of probable cause, I'm not sure if it's clear if you dismiss for lack of probable cause, you can't appeal that.
That's true.
I'm not sure it expressly says if you dismiss for insufficiency of the complaint.
It says dismiss, it says dismiss for any reason in its language.
But even if it seems unfair, the code says what it says. And it says that if you dismiss for any one of those reasons, which are the only reasons you can dismiss, you can't appeal that.
I think you're construing the code in such a way as to make it virtually impossible for a party to appeal.
For a dismissal, that would be correct.
Which is inconsistent with what this court said in the Common Cause Ohio case.
Okay. I see what you're saying. Again, I don't mean to beat you over the head. I just want to be sure to give you the opportunity to deal with that express language in the code.
And that's exactly
I have a hard time getting over.
Well, that's exactly what the trial court said below. The trial court said below they could only dismiss for one of 3 reasons. And our argument is the trial court erred. The trial court statement is inconsistent with OEC.
Now, would you agree your argument would be a lot stronger if they didn't dismiss, but they simply said, we will basically you rule on the merits. They deny the motion to dismiss, but go ahead and enter, it's not really judgment, but rule in favor. Then I see that a much stronger argument, but because they didn't do that, that's where I'm not.
No, you're right. That would be a much better argument.
But don't you think that's the heart of this whole thing, is that point?
No, you're right. No, if you go back to the OEC's action, all the OEC said was we grant their motion. That's what the OEC did. 5-2 vote. Their motion was to dismiss, not for lack of probable cause, not for insufficiency of the complaint, and not for lack of jurisdiction. You can look at their motions, anything about that. But their motions, both the Casey campaign and Casey, were based on affirmative defenses. They argued the First Amendment protected Mr. Casey, and he could do this, regardless of Ohio law, because of the First Amendment.
But is that another way of saying that the complaint is insufficient or not?
That's an affirmative defense, Your Honor.
Okay.
This court,
I see what you're saying.
not this court, fourth District Court of Appeals ruled that an affirmative defense has nothing to do with sufficiency of the evidence. That was a criminal case, but
So you're saying their motion was really premised on the merits, not on...
Completely, Your Honor. One of their...
But there is kind of a... Because even looking at the probable cause, you're sort of looking at the merits and the sufficiency of the complaint, so we're kind of looking at the merits. And maybe this is just a flaw in the legal scheme here, but where that line is between the merits and the lack of probable cause, I'm kind of unsure.
Well, probable cause is more like, is there a 10% chance? Is there a 5% chance? Could a reasonable person believe that maybe something happened? The merits is more preponderance of the evidence.
But sufficiency of the complaints seems to go to legal. Again, I'm it's sort of a motion, it's sort of a 12b6 kind of analogy. It's like there's something in there, there's a fundamental flaw in the legal argument.
Yes.
And the line between those two things, it's sufficiency of the complaint and going to the merits, is blurry to me.
And it's blurry to me too, Your Honor. Along those lines, the Casey campaign argued that our complaint before the OEC was insufficient or was flawed. I'm not sure exactly what the language was they used. Because we didn't include the exact words, with a view toward payment made. They said, you've got to have that language in there. You didn't do it. Well, our argument is you're wrong. That's one way to show it in our Constitution.
But that wouldn't matter for purposes of what we're talking about. Right or wrong is not what we're talking about. What we're talking about here is, does the code allow you to appeal?
Well, it depends on what the OEC did, Your Honor.
True.
Our argument is that the OEC could have done a number of things. It granted their motion, and their motion said nothing about probable cause. So if they're granting their motion, which says nothing about probable cause, it has to be for one of the reasons they presented their motion, which was you didn't include that magic language in view of...
But that might be sufficient, simply another way of saying sufficiency of the complaint.
I can't imagine how, Your Honor.
Okay.
So what was actually before the Elections Commission indicating that there was some coordination between Terry Casey and the Casey campaign?
Mr. Casey's own admission in his answer and his motion to dismiss for the OEC, he admitted that he had coordinated with Republicans. His testimony in the federal proceeding, the federal court proceeding.
I understand, but was that in front of the commission?
Yes, it was, Your Honor. And several emails between Casey, Buchanan, Polosofsky, if I pronounce that correctly, and Matt Carl was the chair of the Casey campaign. And you know what, Your Honor? After the OEC finally dismissed, we discovered a whole trove of additional emails.
Yeah, well, they can't make a ruling based on evidence they don't have in front of them. So I'm trying to figure out, at the time they made their ruling, whether you really had a complaint that stated that he had coordinated it with Casey, or whether that's just what you wanted it to be.
Now, our complaint says that expressly, Your Honor, if you look at our administrative complaint. And the evidence that we did present overwhelmingly established that there had been coordination between the two. Right? The Sixth Circuit, United States Court of Appeals for the Sixth Circuit, 2 weeks ago, ruled against Mr. Earl in a related case where Mr. Earl and the Libertarian Party of Ohio argued that the coordination between Casey, the Casey campaign, and the Ohio Republican Party constituted state action. You need a federal
I understand that we are told by the Supreme Court of Ohio that we don't care what the Sixth Circuit does. The only federal court we are supposed to pay attention to is the U.S. Supreme Court or the Ohio Supreme Court.
Well, no, I'm getting to this because of collateral estoppel. These findings by the Sixth Circuit are collateral estoppel. Mr. Casey was before the Sixth Circuit through his agent, Bell Subsidy. And these findings run against Mr. Casey. Can I quote these findings to you, Your Honor?
You have 5 seconds to do whatever, and then you're out of time.
I can't do it in 5 seconds, but Your Honor, it's public record, and I can send you the Sixth Circuit opinion. If you read the Sixth Circuit opinion, you will see the coordinated activity described by the United States Court of Appeals for the Sixth Circuit between Casey and the Casey campaign.
I understand. Thank you. You used your time. As a matter of courtesy, we'll give you a chance to respond.
Thank you, Your Honor.